My name is Gabe Imperato. I'm a partner at Nelson Mullins in the Fort Lauderdale office. Actually, my office is right below the corner of this room on the next floor. And my personal practice is representing individuals and organizations that are accused of healthcare fraud and assisting healthcare organizations with compliance matters. And I've been doing that either for the government or in private practice for longer than I know Mike Siegel. With that, I'll turn it over to Ed White and Bob Wade to introduce themselves and give you a little bit about their background, and then we'll get started.
And I'm Ed White. Of course, I've been on a couple of these panels, and I'm a healthcare regulatory transactional type lawyer. Been practicing for about 35 years, and I started out as a tax lawyer, so I did a good bit of tax exempt work in the healthcare space as well as tax work, but then migrated into the other regulatory aspects, Stark and anti-kickback. So all this value-based stuff, it's kind of, once you've been doing all the old stuff for a long time, this is just another layer to something we've been dealing with in compliance issues for a long time.
Bob?
Yep, and my name is Bob Wade, and I am here with the firm the shortest period of time. I've been here for less than 1 month. So let me actually go through the rankings of football. Tennessee is #1, and I actually am in the Tennessee office, and I don't believe that ranking is correct because I am from the Ohio State University, and we are #2, but according to the rankings, but I'm #1 from that perspective. So anyway, I have been involved with healthcare regulatory perspective for, about 30 years, and have dealt with a lot of value-based arrangements, fair market value, compensation arrangements. Stark is a huge issue for me, and I have a podcast. So if any of you are geeks with respect to Stark law, fair market value, it's called Stark Integrity, and you can find that on Apple Podcast. And I've talked with a couple of people here about, joining the podcast of, being either an interviewee or with topics for that. So, but I'm really excited to be part of Nelson Mullins. I believe this firm gets it from an operational perspective. And that's huge for a law firm to say, we understand operations. A lot of lawyers and a lot of law firms would say, we can give you all the legal stuff that's out there. But I was general counsel for about 7 years. And during that time, sitting in the GC position, understanding how you implement these issues. And in fact, I've had 3 of my clients contact me when I was in the back of the room saying, please give us some operational stuff because this is what this firm is doing. And I responded back and I said, yeah, exactly. That's the reason why I left my previous firm and joined Nelson Mullins. So I am so happy to be here, happy to be part of this panel, and hopefully be working with all of you in the future. So thanks.
Yeah, we're really happy to have Bob join the firm. I've actually known Bob probably since you started.
Yes.
Practice.
Yeah, when I was born, Gabe was there. No.
And Bob is a true Stark expert and very, very creative in the application of that law. And we're delighted to have him and in our Nashville office. And of course, the other thing about Bob that makes great sense for Nelson Mullins is he's at least 15 years younger than me and maybe 25 younger than Siegel. So anyway, so our topic is, compliance issues when we're talking about value-based arrangements. So to set the stage, when we talk about compliance in healthcare, it's driven by 3 statutes: the anti-kickback statute, the Stark law, and most importantly, the False Claims Act, which ties in the other 2. And we've had a legacy of enforcement actions over the years that have applied these laws, particularly to hospital physician compensation arrangements. Footnote, the False Claims Act has a provision that allows any individual to blow the whistle on any party submitting false or fraudulent claims to the federal government, Medicare or Medicaid. And this provision has created a phenomena in the healthcare industry since roughly 1995 that really makes us operating in a fishbowl with consequences. You can't really get away with this stuff in healthcare. And the whistleblowers and their attorneys will find the ways to make an allegation and to create a case that can result in real liability. In the hospital physician or healthcare organization compensation arrangement, we've had some pretty dramatic cases. The Halifax case here in Florida, back about, I don't know, 10, 15 years ago, probably started.
About 10, yeah.
And it's still keeping Bob very busy because he had to become the compliance expert after they settled the case. The Halifax case was a volume value for referrals case. Okay. So there's a lot of other things associated with Halifax, but in its bottom fundamental basic way, it transgressed the prohibition on paying physicians based on the volume or value of their referrals. Then we had the Toomey case in South Carolina, which basically was a case where the hospital felt like they had to figure out a way to pay the physicians for referrals, and they did it in the form of part-time employment agreements that really didn't hold up to scrutiny. Closer to home, we had the USX Riley versus North Broward Hospital District case, which I would characterize as who cares about fair market value? We're paying the physicians $1 million, and the consequences eventually came home to roost there. We have more recent cases that take advantage of the loopholes and vulnerabilities in compensation arrangements. Right up, there was one case I found recently in 2022 where I guess the whistleblower was a physician who alleged that the hospital used its employed physicians to cover for the cardiology patients of another medical staff physician who I guess was on vacation a lot. And in effect, the theory of the case was that the hospital used the employed physicians to cover that physician because that physician referred so much work to the hospital. Now, it was never really proven in a case that was adjudicated, but these cases don't get adjudicated, they get settled. And it was, a settlement for $3.8 million. So with that legacy, we come to our value-based arrangements here, and the amendments to the Stark Law and the safe harbor created under the anti-kickback statute are actually the result of fairly significant long-term lobbying, I think primarily by the hospital industry, where they, for years, were wanting or trying to do value-based arrangements, but we're always sort of running into, well, might that violate the Stark Law? Or aren't we exposed to that violating the Stark Law or the kickback statute if we have these kinds of financial arrangements? There was no protection for what the industry was experimenting with. And so there was a lobbying effort with CMS to give some protection. Of course, CMS was really kind of, happy to do this because of the cost containment features of value-based arrangements. And they really want to promote these arrangements in a way that will benefit Medicare and Medicaid programs. So lo and behold, eventually these get promulgated January of 2020 and then in effect in 2021. And Ed will tell us a little bit about what these exceptions are and what their features are. And then I'm going to turn to Bob and ask him, let's talk about what some of the compliance opportunities may be here, because you can rest assured that while these regs are somewhat of a safe harbor for what we want to do in creating value-based arrangements, it will only take a matter of time before there are vulnerabilities exposed and being the basis for whistleblower cases. I kind of equate it to what we saw in Medicare Advantage plans. There were so many years where people were trying to figure out, okay, this is capitated payment. Is there compliance issues going on? And if so, how would that work? Well, of course, now we're starting to see the risk adjustment cases coming out of the woodwork as managed care plans are accused of playing with risk adjustment to get increased reimbursement. So,
And Gabe, if I can,
yeah.
how many Quitam relators do we have in the audience? Actually,
Well, at least today.
yeah,
Yeah.
I asked that question at one conference. Usually it's a joke, but there at one conference there was this individual at the back and they put their hand up like this and they said, "I am a Quitam relator," and so that's what we're dealing with here, because there are issues and we're all going to discuss this, but this is a great opportunity for healthcare organizations, but we have to be cautious because these issues and the compliance with respect to how we deal with value-based arrangements, if we don't do it right, we're going to have a Quitam relator.
Yeah.
And so whoever is in the back of the room, way back there, those are the people that we're concerned about, because those are the people that will bring these issues forward, and then we're dealing with a settlement. And so,
And if I can add to that too, it's often people close to the company. It might be a competitor, but it may be a disgruntled employee,
exactly.
maybe somebody that had an inside information. And I remember one time we had a matter where we had somebody was billing incorrectly, and we told them how to fix it and how to self-report and all that, and they didn't do it, and they got into a dispute with one of their partners a couple years later, and the office manager said, well, the lawyers told them to do X, Y, and Z, and they never did it, and then brought in a key tammer. The dissident shareholder became the key tammer later, and what could have cost probably $16,000 to self-report, they spent $200,000 in legal fees and fines and all that kind of stuff. So
we've actually seen a proliferation of physician whistleblowers in the last, I would say, 10 years. So,
yeah. And in the Halifax case, it was almost $25 million in legal fees. So, and we're not here to generate those type of legal fees, but that's what they charged in that case. So our hope is to be on the front end with these issues to make sure that there's no way that any of us are going to be in that ballpark with respect to legal fees.
So Ed, tell us what the requirements and the advantages of getting into these value-based arrangements.
Sure. So basically, we talked a little bit about this earlier, but as a starting point, these are new regulations under the Stark Law, the exceptions, and under the anti-kickback statute, safe harbor. And of course, safe harbors are not mandatory. Exceptions under Stark are mandatory to prevent a violation. These only apply to compensation relationships. So anything that's in the nature of an ownership interest, you look to what I call the classic rules, the classic Stark and anti-kickback. Safe harbors or exceptions. And at the center of this whole concept of these new rules for value-based arrangements is this concept of a value-based enterprise, which we talked about earlier. And that can be as simple as something in a contract, which means that if it's just a contract between two parties, then it might be something that goes in a drawer and nobody ever pays attention to, which we'll talk about some of those issues. But or it can be as sophisticated as a separate legal entity with its own board. It could be an overlay over a SIN or an ACO, or it could be an adjunct to those. But the basic requirements of value-based enterprise, it's 2 or more participants, and it has to have at least one value-based purpose, and there's 4 purposes that are in the regulations. Care coordination, can be your objective. Improve quality, reduce costs, or help the providers transition away from fee-for-service to value-based payments. You get, as I mentioned earlier, this is like your own innovation center. You get to create your own protocols, your own action steps. You define the outcomes you're going to measure. You even get to define the target patient population. So you don't have these rules of attribution. You have to define it in writing in advance what you're doing. That's another place that you got to pay attention to the details. It's got to have a governing body with financial oversight, and monitoring what's being done and making adjustments. If you're in the care coordination model, we talked earlier, there's 3 models under these regulations. They were drafted by the 2 agencies largely working in tandem. There's some distinctions between the anti-kickback statute, safe harbors, and Stark. But for the most part, they tried to synchronize as much as they could. And under the care coordination model, there's no risk required in that model, and you can have disproportionate. You can disproportionately, subsidize the startup cost, et cetera, much like an ACO can do in the startup phase of an ACO. And the partial risk and full risk models, we talked about that earlier. You do have to start bearing some form of risk in the partial risk model, and the full risk model is more like the capitated payments. The big sort of prize in all of these new rules is there's no fair market value standard. And so in the care coordination model, the Stark, there's no fair market value standard. You mentioned the Toomey case. I'm from Columbia, South Carolina. That's 40 miles away from Toomey Hospital, and every healthcare lawyer in South Carolina was following that case for probably, 8 or 10
maybe
years.
Even representing somebody. In
Yeah,
the case, right?
and actually, my partners represented the hospital in their workout after the $276 million judgment in federal court. So that was a biggie, and it was probably 12 part-time physician contracts. And they failed the fair market value standard in the first trial. It was retried. They lost both the Stark violation and the False Claims Act violation. And so, and that organization literally had to sell itself and negotiate down the judgment. So the hospital is still open, it's still serving patients, but it changed hands as a result of that and took a lot of negotiation. The volume of value standard, there's no volume of value standard. Once you get into these rules, the one nuance or exception, the distinction the OIG makes that CMS was more generous in the care coordination model where there's no risk involved. And risk is an important piece because we talked a lot about it today. But what both agencies have said is that there are more controls over utilization and a party wanting to compensate another party for referrals in a risk-based or partial risk-based model than anything they can put in regulation. So the government sees this as a natural safety valve to incentivize, people from protections from payments for referrals and overutilization. And in the care coordination model, it can be the anti-kickback safe harbor doesn't allow, there's no risk involved. They don't allow anything but in-kind remuneration. So you can put resources into the value-based enterprise that the typical rules when you look at the anti-kickback statute, when you're dealing with referring physicians and other entities that can be the recipients of referrals, is your starting point is everything's proportionate. And so that doesn't have to be the case. But if you're going to pay cash compensation in a care coordination model, there is an additional safe harbor. It's not in these value-based rules per se, but they did modify it to allow for outcome-based payments, but they still have the fair market value requirement there. And the volume of value prohibition has not been removed there. The nice thing about these rules is that when you plug parties into a value-based enterprise through participation agreements, that you can require that they refer back to other participants. So you begin to you aggregate networks, or you aggregate aggregators, and we look at like ACOs and SINs and whatever. If you've got physicians that are combined, and one of the panelists earlier talked about the need to really put resources with providers to help them take the extra steps and go the extra mile in value-based care. So you can do that here. You can subsidize that here. One of the things, some of the key distinctions, and of course, as a lawyer that's practicing in the area of healthcare, it was always, I'm going to try to get to a page here if I can.
Hey, Ed, let me ask you a question. So does that mean that like a hospital could subsidize the creation of a value-based enterprise to get the ball rolling,
Yes.
basically, right?
Yes.
Or other healthcare organizations?
Yeah. Anybody that wants to form a value-based enterprise, you can have investors in a value-based enterprise, and it's not a provider of healthcare services directly, so it's not going to trigger the same stark implications. But a couple of and this is the first point on this slide, notable distinctions in the value-based regulations from the classic Stark. That's the old stuff. So if you're not in these rules, you don't have the value-based enterprise in place, and you don't meet the requirements. Let me go back, digress 1 second. If you're in the care coordination model, which is really the most liberal, where you can subsidize care coordination steps, can have in-kind contribution under the safe harbor thing, kickback statute. There's more requirements into that model, and you have to annually evaluate your steps and your activities and your protocols to see if you're accomplishing what you set out to accomplish. And you have to put what you hope to accomplish in writing in your documents, in your governing documents. And so if it's not working, I mean, you've gotten this generous exception and safe harbor. And if it's not working, it doesn't say it has to be working by any particular percentage, but it just, if it's not making some progress towards moving the needle towards your objectives of increasing quality, lowering costs, care coordination, et cetera, and moving away from fee for service, then you have an obligation to either modify it or terminate that particular activity. And the idea is that they don't want you doing something that doesn't have any real, you're not accomplishing something. But the good thing about it is you still have the exception or the safe harbor for a period of like 60 days, once you make that determination assessment. So for compliance in that care coordination model, coming back and the board of the organization, monitoring that's an important step of staying compliant. But
so Ed, I mean, how would you, what kinds of ways do you demonstrate that your care coordination model is achieving your, some of your value-based purposes?
Well, you have,
this is kind of important because, we're dealing with the Stark law here if we're talking about an arrangement between an entity and a physician. And the Stark law is a strict liability statute. So if you're not achieving your value-based purpose and can't prove it, that's to me is like a vulnerability, right?
that's right.
So how do we get there?
If I can jump in, because actually I wrote down a point here. I actually, in my mind, when I deal with executives, when I was in-house, I said, how can I bring this point home? And that is, we can build a car. And we can build a car around these value-based arrangements. The question is, can the car run without lug nuts? And the lug nuts is the compliance component. Can we demonstrate that we have the ability to evaluate each of these components under this arrangement through a lug nut? And in fact, I had a conversation with a client, and they're probably participating today, when they had this complicated arrangement. And I said over the phone, I said, this is all compliant, but can you monitor this arrangement? Can you implement the arrangement? And can you operationalize what you're trying to do? And they said, well, this person over here is going to do this, and then this person over here is going to do this. And the problem is that if we don't monitor the exact requirements under this exception, then you all are going to call us and said, oops, we've had a material failure. We didn't have, and we'll go through some of the big operational issues. We've had a material failure, and now what do we do? And that is, we've fallen outside of this exception, which reverts us back into the fair market value requirements under the Stark Law. So if I didn't prepare for this. Actually, when Ed was talking about this, lug nuts went into my head. So just think of lug nuts. You've got to push those lug nuts into the tire, because otherwise we can build the car. It'd be a beautiful car, Lamborghini or Corvette, whatever. But if the lug nut is not correct, then the car will not drive well. And so that's when the car will fall apart. And that's up to all of us to make sure that we have the appropriate compliance lug nuts to push in to those wheels to make sure that this car will drive appropriately. And I think that's the important point of this conversation, is just to make sure that, we have all these requirements. This is a beautiful exception, but there are major catastrophes that can happen if we don't have the appropriate operational oversight on these issues.
And I think to respond to both of y'all's comments, I think, Gabe, from your perspective, you have to define outcomes and you have to capture that information. You're basically counting outcomes. If we do, however you define it, you got complete. But if it's care coordination, you got somebody they're admitted to an urgent care center and they need to get to a primary care physician if they don't have one. How many days to help them schedule a patient if there's follow-up care.
So this is all data that really starts in the electronic health record, basically, right?
But it's a process you have to follow. You have to follow the mechanics of capturing your own data that you're tracking, your outcomes that you're defining. And it's easy not to do that. It's easy for busy people not to slow down or not do it completely. And so I think that, another point I want to make, when we talk about fair market value, we're talking about removing, when we say there's no fair market value requirement, we're talking about removing a compliance risk. Again, Toomey Hospital, $276 million because their appraiser's report couldn't stand up in court. And it doesn't mean you pay them more fair market value. You might still, because if you're a 501c3 hospital, you've got a private enrollment and private benefit prohibitions that still have fair market value components. And the way I've heard hospitals talk about this is really a matter of funds flow. When you take the compliance risk away, you still don't want to be making bad deals. You still want to have everybody, makes a return on whatever you're collaborating to do. But if you are all fair market value, and I think the genesis of these rules is you're going to be negotiating these value-based payments, and they're going to have risk components, and things are going to be transitioning. At some point, you're going to migrate towards partial capitated and capitated care, and it's going to get harder and harder. You're going to be defining fair market value based on the level of risk.
Right.
But and that's another point for the fair market value for the 501c3 organizations. This question of fair market value it's a continuum, but it's constantly evolving as these arrangements get more sophisticated. But
if I can, Ed just said that fair market value is not a component of this exception. But I'll give you one example. So part of this exception is that you have to have a governing authority. So you have to have this committee or a board that's actually having this oversight of the activities of the value-based arrangement. And if we cannot document the fact that there is this oversight, then we fall back into a fair market value issue. Now, if we have that documentation that we had a board committee oversight, then fair market value is not an issue. But then the qui tam relator is going to say, well, these doctors never met. The board never set up a governance authority over this value-based arrangement. And because they didn't set that up, then they're going to say, well, then there's no oversight. And that's one of the components of this exception. And that's going to throw us right back into the fair market value issue. And the fair market value issue is
completely undermine the application of the exception.
exactly.
Yeah.
And then what you have to do from a fair market value perspective is that what services were provided, how many hours were provided, can we back into the rate? Let's say we paid them $100,000 in that year. How can we evaluate that $100,000 on a per hour basis? That's when we fall outside of this exception. As long as we're living within the exception, we're good. The problem is, and that's the point of this presentation, is that if you fall outside of this exception, then we fall back into the fair market value stuff. Then you have to go into the personal services arrangement exception, the fair market value exception, et cetera. But this exception is a beautiful exception as long as we are strictly complying with the requirements. So one of the requirements is the governing authority. Do we have a board? Do we have a committee that is meeting for the oversight of the things that Ed talked about? And as long as we have that, then we meet that one component. All we have to do is to have one person in our organization and say, they've never met on this issue. And I had that conversation with a client actually this morning who said, well, under this exception, it appears to be a very broad exception. Can we just pay doctors to refer? No, you can't under this exception. You can create these quality indicators, as Ed talked about, all of these various indicators. As long as we're fitting within those indicators, then we're going to fit within this exception. So it's an operational issue that if we're going to form a value-based arrangement, just make sure that we're compliant, because otherwise we fall outside. Then fair market value pops up. What is that? When the groundhog game?
Yeah.
So when the groundhog pops up and you can't pop it down, then fair market value becomes an issue.
I see Daryl Johnson here. You see, you'll have plenty to do no matter what, Daryl. Yes.
So yeah, and you mentioned a point too, under the care coordination for START, one of the activities that is permissible is you can require referrals.
Absolutely.
You can't do that outside of this value-based rule. So if you have that as one of your components of your care coordination program that you're going to refer a certain way, it's absolutely critical you stay within the exception.
And
Yeah.
Ed, why don't you talk a little bit about, so you have care coordination, partial risk, full risk, value-based purposes, quality cost, coordination, and moving from fee-for-service to risk. Kind of the runway concept, for an organization, kind of starting here, but, moving along the spectrum.
Sort of the evolution.
Yeah, and its relationship maybe to compliance.
I go back to the chart we had out earlier. This is sort of, the care coordination is what I would say sort of these rules are designed to allow anybody of any level of sophistication to start moving towards learning how to do value-based contracting. And so this slide we had earlier is what I would call an evolutionary concept, a facility or entrepreneur, anybody who creates a value-based enterprise. And you need, obviously, the group or groups to to partner with. In the first level of that, the creation, you would document your activities, you would set up your board. I mean, one of these conversations we're having right now, if you just do it in a contract, even though it's permissible, and you put a contract in a drawer, how many stories have we ever heard about? They just put a contract in a drawer and it's never come out. Nobody's ever done anything.
Yep.
I don't like those. I mean, some people are going to do those, but I think when if you've got the long-term view, setting up a separate legal entity with a board that has regular processes they follow and they meet, they do the oversight, et cetera, that's sort of your big compliance step of trying to maintain this, particularly as you accumulate. And you can start with anything. You can start with your self-insured fund. If you have a large workforce of employees, you could start there and paying physicians to work on care coordination. That's the step 2, where here we've got a facility, could be a hospital, could be a large group, could be a surgery center, could be a health system. It's creating a value-based enterprise. There's not a payer involved yet. It's funding the capital to run the programs, and it's basically disproportionately subsidizing the care coordination efforts. If you're going to pay in-kind contribution, you have the benefit of the anti-kickback safe harbor. If you're paying cash compensation, which I have in that second step, you're going to need that outcome-based payment safe harbor. But this is one of these departures because the Stark exception of care coordination, it's just complete, no fair market value, no volume and value referrals. But if you're paying cash compensation in a care coordination model, you're going to still need the fair market value distinction. And some people, can decide this is one of those departures, the anti-kickback statute safe harbor from the Stark law. There's a couple of places. And you don't have to be in a safe harbor, to do a transaction. We lived in the early days of healthcare consolidation in the 90s when all that was coming out of the ground. You could barely, there's a lot of transactions you just couldn't get in safe harbors because they couldn't fit the reality of transactions. But here, I think, this is a concept, Gabe, you and I've talked about a good bit, is if you're following the value-based enterprise, you've documented your value-based purposes, and you've laid out legitimate value-based protocols, and you're doing the governance, et cetera, then maybe you don't have to be in safe harbors all the time because you're documenting your intentions of, fulfilling this government objective of having people move towards the value-based
Well, and Gabe,
contract.
if I can, there are 6 ways that you can fall outside of this exception. And these are the operational issues. So if you're walking away from my perspective, and I drafted an article that you guys, I believe that we have provided it to you. So, first off, if you don't have this governance oversight, then you fall outside the exception.
But by the way, when we talk about governance oversight,
Right.
it's pretty fundamentally been communicated in all industries, but especially in healthcare, that boards, governing authorities are responsible for compliance oversight. This is just about slotting this piece into that.
Correct. And it does not need to be through the board.
Yeah.
It can be a committee of the board. It can be through the medical executive committee. It can be through doctors. This is not specifically ran up through the board of the hospital. So there just needs to be a committee that is actually responsible. That's point number 1. Point number 2 is there needs to be a legitimate and verifiable criteria to evaluate your activities. So whatever the value-based activities, let's assume is care coordination, you need to have a way to evaluate your care coordination, reduction of expenses, everything that Ed talked about. If we're not able to evaluate that, then you could possibly fall outside this exception. So that's point number 2. So the first one is governing an authority. Secondly is that we're not, evaluating the criteria for the value-based arrangement. Number 3 is the patient population. So let's assume we're doing with one zip code And we're saying that that is the patient population. You slide one participant outside of that population into the value-based enterprise, all of a sudden you've blown it. One patient.
And the takeaway there is don't use zip codes to define your target
Yeah,
patient
well,
population.
and you actually, you can, and I've had this one also with Medicare. You had a Medicare participant, all of a sudden you slide in a Medicare Advantage participant into the patient population. It was not Medicare General. And so the whole theory of the organization was just Medicare General, not Medicare Advantage. And so you slide that into it, that blows it. So the next one is the value-based purposes. As Ed pointed out, there are various value-based purposes. You blow one of those purposes, you're now outside of this exception. There's also a patient swapping issue. And that is that I go to a physician and say, we want to enter into this value-based arrangement with the Medicare population. You're a cardiologist, and we want you to assist us with respect to a quality-based cardiology arrangement. And this is going to be for Anthem or a third-party payer. You slip in a Medicare participant, now you've blown that component of it. Patient choice. One of the requirements that we've talked about today is patient choice is still key. You blow the normal, conditions of participation for patient choice, and the patient would say, I didn't want to be part of this arrangement. And then you blow that component. Now we're outside the exception. And last is the record maintenance. So this is point number 6. So you're supposed to keep all of these records for 6 years. Let's assume in your organization, you destroy them after 4 years. Now you've blown the exception. So all of this stuff becomes a compliance issue, then goes back to fair market value.
So I guess, if you're going to take advantage of these exceptions, you got to be able to create the platform to do it.
Absolutely.
And so it's not just oh, let's do this tomorrow. An organization has to be prepared to launch this and have the platform to do it.
And
that's somewhat of a lift.
We probably have said this before to many clients. We can create the greatest model for all of you, but that's not where the compliance issue is. It's how you implement what we have created. That's the lug nut issue. And maybe I'm going to coin a phrase. Everybody's going to say, "Oh, Bob says it's the lug nut issue," but it really is. Is how do we operationalize this to make sure that we are compliant through this process? Because once we blow it, and with the client I talked to today, and they're probably on again, they're going to pay above fair market value to these doctors. And I'm okay with paying above fair market value to these doctors as long as we're fitting within this exception. But I started walking through this model and they said, oh, we cannot manage that. And so I said, well, if you can't manage that, then we've got to fall back into the fair market value exceptions under Stark law. And so it becomes a glorified medical director issue, medical directorship issue, versus a quality value-based enterprise issue. And that's the point. Can you operationalize it? Can we put the lug nuts into the will?
So that must eliminate some potential players who really don't have the wherewithal to develop this platform to make sure that it's a compliant endeavor. Yes or no?
I say yes, but if you want to balance that, I mean, we're talking about processes. I mean, somebody said it earlier in terms of, and I've seen this too, particularly with some of the aggregators that are, bringing groups together to negotiate through, ACOs or DCEs. They say, oh, this is a value-based enterprise, and there's no evidence of any of that. And just we heard that earlier. You can't just put that label in a contract. I think these protections are going to come into place.
Yeah.
But you think about it. I mean, we had one, they had to do their annual review here in September. And, I was a little bit concerned, but they were coming together and they were documenting. It was getting close to the end of the 1-year period to document and we had to help them. And that's where lawyers, we can help, help people bring it to a conclusions in that reporting period. But it was the steps that you talked about, making sure you documented these outcomes, you recorded that, you've got minutes of the board meeting. It's not the corporate board, but it was the board formed for the value-based
Now,
enterprise.
and here's an interesting issue. Can we compensate a doctor under the fair market value exception on an hourly basis to monitor the effectiveness of their implementation?
I was starting to think.
You
shit.
can.
Well,
Yeah.
I mean, that's like another business opportunity. Who's going to do that? Who are the candidates to do that?
Yeah,
Consultants, doctors? I don't know.
Yeah, yeah. And we can evaluate the fair market value of the physician oversight for that process. But that's where, to me, this really takes the physicians, attorneys, whether or not it's in-house or outside, and also consultants to work together to make sure that we've got the correct documentation to fit within this exception. This exception is a beautiful exception, but you blow one piece of it, and then, as one of my daughters has said, "Dad, you're hosed." So, and that's sort of what it is.
Well,
Yeah,
listen, in the real world, the way this works is, if you're not accomplishing what you need to take advantage of these exceptions, and you're just moving along and ignoring really the compliance requirements,
Yeah.
somebody's going to blow the whistle on you sooner or later.
Oh, yeah.
I mean, that's just the way it works.
There is a cost of implementation. So let's not be naive with respect to that, because some people are going to say, just show me the contract. And I've actually had doctors do that with me before. He said, here's the contract that they did in Colorado. And I would look it over and look at the doctor and said, are you actually doing all this? And said, no, the hospital's doing that. We have to make sure that we are monitoring this exception. And it sort of sound like I'm Pollyanna out here and saying this is really difficult. It's not, as long as we dedicate the resources. And
Well,
so
you know what
it assists us.
it's really sort of makes me think of compliance program effectiveness.
Exactly.
That's really what it boils down to.
Yeah.
and this is the kind of stuff you'd want to wrap into a compliance program.
Yeah.
Oh, yeah.
And
Compliance should be front and center with all of this.
but the flip side of this too is you think about it, it's really not that hard. It's just over the passage of time, getting busy people to stop and do this. But to me, the one we worked with this year, the most exciting thing about it was they were not only recording and we were closing out, they were getting close to the 1-year period, but they were already thinking ahead of what more they can do next year. What additional product, and that's the whole idea of this evolution is you evolve, you innovate, you layer stuff and you decide what's effective or what additional things you can be doing. And you just take it one step at a time. But one of the flip side of this thing about the concerns is, Gabe and I have several times given presentations where he talks about the enforcement actions. I talk about these new regs. And he goes to the enforcement stuff, and I listen to all the volume of value and fair market value, and in real time come out and say, we wouldn't have Bookwalter, we wouldn't have Tim, we wouldn't have Halifax had we had these rules in place.
Yeah, and the beauty
and that's the price you save
of lawyers understanding these issues, and that's the reason why I came to this firm, and that is because not only do we ask the legal question, we can create this box for all of our clients. The next component is compliance. How do you operationalize this issue to make sure that we don't have a qui tam relator? That's the issue. And that's what causes these $270 million issues. And as Gabe said, I've sat around with the board of Halifax where the board members were looking at me and said, how could we have done something differently? We looked to the lawyers, and the lawyers actually told us that this was
that's
defensible.
there's a good story on that, and I think it really portrays the risk out there.
Yep.
So in the Halifax case, there was an interpretation of the Stark law made. But Bob can verify this for me. And
a 2-page memo.
right, and I will tell you, at the time, I might have given the same advice about the application of whether you can pay a doctor a productivity bonus based on their personally performed services.
Yep.
Okay, it was considered a reasonable interpretation of that application to say that in the Halifax context, if the doctors referred for chemo that created a pool of money and they split it up based on their E&M services over here, that it met the personally performed service requirement for a productivity bonus.
Correct. And the pool was from the technical component.
Right.
So the pool was in the oncology department. There was if they exceeded the budget by 15%, that money was pushed into a pool divided based upon their work RVUs.
But it was their work RVUs over here on the E&M side.
Correct.
They didn't personally perform that service, okay? Now, as lawyers, we always thought, yeah, that might work because we just had the statutory language and we were saying, yeah, I think that could work. Well, guess what? That issue finally got before the court in Orlando in the Middle District of Florida, and a judge said, I don't think that's how it works. If they had personally performed the service, they could get paid. And that was the end of the Halifax case, when they decided that.
And that's the reason why in this presentation, we don't want to talk about that. Because if we fit within the value-based arrangement and strictly adhere to the requirements under this exception, we don't have to talk about the volume or value and compensation.
Yeah, the other moral of that story is that managing the risk of compliance does not really evolve on the head of a legal interpretation.
Correct.
It's more than that.
Correct.
It's much more than that.
It's operational.
What are you waving at over
It's
there?
5 minutes.
Yeah.
5
And
minutes.
we have a
All right.
question.
Do we have any questions?
Yeah, we have a
Yes,
question there and
Heather.
back there.
Can you get the microphone? We got virtually.
So Bob, I think you alluded to this in one of your prior comments. Let's say you have someone that fits squarely within the safe harbor or the exception. Every box is checked. The lug nuts are on tight. Okay, it's going. But there is a component within that model whereby the VBE is paying physicians for referrals. But the referrals help support the quality component. Do you think that would create a compliance issue?
I'll answer this in 2 ways and look to Gabe and also Ed to provide insight to this. I think that as long as we are mandating the referrals and that the intent is to mandate the referrals in order to evaluate the quality under the value-based arrangement, then we're totally fine. But if there's and all of you have received this before, a stupid email that comes out that said, we're only doing this because we want to induce referrals from these physicians, then I think we've got a greater problem under the anti-kickback statute. I think we're okay under Stark, but under the anti-kickback statute, I think we've got a greater problem as long as somebody can advocate that there is one technical problem under the AKS value-based arrangements. Because again, what we've been talking about is the value-based arrangements both under the anti-kickback statute and the Stark law. And so that question really swings more toward the AKS. I think we're going to be
Yeah.
okay under Stark.
Yeah,
It's the
I
AKS.
agree with that, but I think something that Bob is portraying here that comes into play with this whole whistleblower phenomena. What do the optics look like? Because the whistleblowers play on the optics. They don't know exactly the whole story.
Yeah.
When we look at whistleblower cases and we read the complaints, oh, that's 40% of the story, but that gets traction. So you got to and that goes to what I said about, look, it's not about legal opinions. It's about managing the risk. And the sort of offhand email, that creates bad optics.
Yeah, and I was a compliance officer for 7 years in a hospital system. And sitting down with these people that are bringing issues to the attention and holding their hand through this process. I'm not talking touching, but just really going through the legal analysis. And I would say 99% of the time, as long as I am compassionate and understand what they are talking about and say, these are the regulations, sometimes they don't make any sense. In the Stark law, even though I make a lot of money off of the Stark law, it's a stupid statute. But if I can explain that to a potential qui tam relator, it's okay. So for the most part, I distinguish or I lessen the probability of an issue. So that's where the compliance department comes into huge play here. Just make sure that we are interacting with our people to try to make sure that they understand the analysis, we understand their concern, we understand the optics. The optics may look bad, but from a regulatory perspective, just because the optics look bad doesn't mean it's illegal.
The only problem is the bad optics create the whistleblower case, and then you get to talk about the legality stuff in the defense of the case.
Yeah. But
you want to try to avoid.
But when I was in-house, I was able to, there was probably close to a dozen cases, I think I was able to control that person going to the government over an issue that they were trying to report. Your compliance person becomes really, really critical. Sometimes my wife says I'm overbearing. But I don't think I am. I can be compassionate. I've had Kleenex on my desk when I was compliance officer to actually.
That's a tough road
Yeah,
to hoe.
to really talk to them about that. That's where this issue, this whole presentation is about controlling the optics.
Well,
I think
you know,
you're right,
you know what it boils down to. It's something that I say all the time. An organization in healthcare, especially, an organization ignores even a peep of a report of non-compliant activity at significant risk. You got to respond to it.
Yeah.
You know?
And one time I was in a compliance committee meeting and I was a compliance officer. I chaired the committee and it was an anonymous call. And one of the persons on, he's actually was our chief operating officer. He said, Bob, if this person is not going to reveal their name or their identity, we should just disregard it.
Yeah,
and I looked at them and
yeah,
said,
that's
you
dangerous.
have got to be effing kidding me.
Let me, if I can.
We're getting the hook here.
Before we wrap up, I want to make one point on what y'all are saying, because it's a very important point. Gabe and I have spent a lot of time talking about it. I know Bob and I will spend time talking about it as well. But the positive side of this is all these steps and documentation of your activities and how to accomplish under value-based enterprise. The positive that can be an important part of documenting your intentions. And if that is truly what you're doing in this effort, and one distinction is the Stark law allows you to, one of your value-based activities can be requiring referrals. And so that's a distinction that you normally don't do that directly, under a safe harbor than any kickback statute, you can't. But the other distinction here is it's the Stark law that also brings you the ability to restrict referrals. Mm-hmm. And you can actually have a wider network than perhaps you would get under the classic Stark of protection for restricted referrals under a value-based enterprise. That's another reason you want to make those affirmative showings in your documentation of what your purpose is. You're following these objectives of of transitioning towards value-based care, and you want to leave all this loose language out. But it's a tool because you don't always have perfect parity between the Star Clause and the anti-kickback statute.
No.
And this is another reason not to say, okay, I can't do it. I can do it if I do it
And just
in a
remember,
prudent and disciplined way.
the Stark Law is a billing statute. The anti-kickback statute is a criminal intent-based statute. So there are two different worlds that we're talking about here, but they all focus through to the False Claims Act, as Gabe.
Yeah, so
Pointed out.
listen, to wrap up, I guess I would say if you're going to contemplate taking advantage of these value-based, and don't think you can just wake up in the morning and do it in 24 hours. You kind of need the infrastructure and the
ongoing
platform.
process.
Yeah. Okay, thank you so much for your attention. Tom?